Hi everyone. So we are up with the next video. In this video, we'll be covering question number 4 in the civil paper for AP JCJ mains examination. And this question is having 4 sub-questions, 4A, B, C and D. So in this part 5 of this video, we'll be covering all the 4 questions. So if you have any doubt, kindly make a note. So if you go to the question, so question number 4 is of 2.5 marks. So it consists of 4 sub-questions. And the first question 4A is, when can a person file a suit for recovery of possession under section 6 of Specific Relief Act 1963? So in this question, this is a direct question asking section 6 of Specific Relief Act. So what does section 6 of this act states? So it states that section 6 is sued by a person who is dispossessed of his immovable property. Immovable property. So if a person is dispossessed wrongfully or illegally from his immovable property without his consent, then that particular person or any person on behalf of him can file a suit for recovery of possession. So this suit is for recovery of possession, and this has to be filed within 6 months from the date of dispossession. And the conditions to file for a recovery of suit, so recovery of possession, so the condition to file a suit for recovery of possession is the person should have legal right in his property, and the property should be of immovable property, and this property is dispossessed by him without his consent. So he has to have legal rights, and the property should be immovable property, and it has to be dispossessed from him without his consent, either by force or taken wrongfully or illegal. And this person, out of good faith, have to file a suit for recovery of his possession within 6 months of time. So these are the conditions to file for a recovery of possession. Okay, so now we'll go to next question. This is one of the important questions. So it's very difficult to understand, but you can break it into the parts. So when does section 25 of Contract Act relax the rule that acknowledgement of debt after expiry of limitation period would not extend the limitation? So here this question is from Contracts Act. So if you look into section 25, the section 25 of Contracts Act states, at any agreement without any consideration, so an agreement without any consideration is void. From the beginning, it's not treated as a contract, right? So any agreement without any consideration do not form a part of contract, and it is treated as void. But it has certain exceptions. So this can be treated as void, but still, unless it is in writing. Suppose if this agreement is in writing and is registered, or if a promise to compensate for something, so this agreement is regarding a promise to compensate something and is a promise to pay a debt, or is a promise to pay a debt which is backed by limitation. So if you look into the section as a whole in the Bare Act, you will find all these elements under section 25 of Contracts Act. So in this act, we'll just go through the section once again. So this says agreement without consideration is void. So you have understood this statement. But there are certain exceptions. Even though agreement without consideration cannot be treated as void if it is in writing and registered, and if it is a form of a contract which is on a basis of promise to compensate something, or if it is a promise to pay the debt which is backed by limitation. So these are the exceptions. So now if you can go through the question and read it, what they are asking is, when does section 25 of Contract Act relax the rule that acknowledgement of debt after expiry of limitation would not extend limitation? So now we will see regarding acknowledgement of debt and expiry of limitation. So here it states that an acknowledgement of a debt. So generally, acknowledgement of a debt by the debtor after the expiry of limitation, after expiry of limitation period would not extend the limitation. So here, for example, A is acknowledging. So A is a debtor who has taken some particular amount from B, for example. So this person is creditor and A is debtor. So here debtor A has taken some amount from creditor B, say for example some 10,000 rupees, and he has to pay this 10,000 rupees within the time fixed by the creditor, that is within 1 year of time. So 1 year of timeline, A has to pay 10,000 rupees of debt taken from the creditor B. So here what does this statement says is the acknowledgement of debt. So here A, what he is doing is he is acknowledging that he has taken debt from B even after 1 year of timeline. So he is giving his statement even after the expiration of the limitation which has been given to him, but still he is giving a statement that even though the limitation period is expired, even though I did not pay the amount within the time to be, the actual situation is I have taken 10,000 rupees from B and I need to pay that amount. So now we'll look into this scenario. So an acknowledgement of a debt after the expiry of the limitation period will not extend the limitation. It will not extend any previous limitation. So even though A acknowledges here that he has to pay some 10,000 rupees, this 1 year of time will not be extended. But if a debt is time barred due to the expiration of the limitation period and a subsequent acknowledgement of debt by this debtor who has made the acknowledgement, it can be treated as a fresh limitation period from the time which he has acknowledged. So the situation here is the previous limitation period will not be extended, but still if he acknowledges after the limitation period, from that date it will be treated as a fresh limitation period. So here if the debtor after the expiration of the limitation period makes any payment or acknowledges the creditor, the fresh limitation period will be started and the creditor can file a suit for the recovery. The creditor can file a suit for recovery.